So the battle over the Texas border and the current immigration crisis just got even more interesting and a little bit more complicated after a new decision that was just issued days after Trump won the election. Now, really quick before we jump into this video, I want to thank the sponsor of this video, which is SimpliSafe. SimpliSafe is the only security system that I actually trust with my peace of mind and I trust to protect my home and my family. In my opinion, there is no safe like SimpliSafe. As someone who values personal security, obviously, and the protection of what matters most to me, I can't stress enough the importance of having a reliable security system to protect your home and your family. SimpliSafe isn't just an alarm system like other companies. It's actually designed to protect you from all angles with sensors, cameras, and personal monitoring, which actually takes place 24/7, 365, and helps you respond to any situation. I trust SimpliSafe with my protection, and if you would be interested in SimpliSafe right now, you can actually save 60% on your SimpliSafe security system with a professional monitoring plan, and you can get your first month absolutely free. Just go to simplisafe.com/armscholar. You can click the link down below that's going to be in the detail section and then also in the pinned comment, and you can get your own customized security system. So check out SimpliSafe using the links down below. You can try it risk-free, and you have 60 days to return and get a full refund if you don't like it. So check it out using the links down below, and thank you again to SimpliSafe for sponsoring and supporting this content. As I mentioned in the intro, in this video, we need to talk about a new decision that was issued just days after Trump won this election. We all know that the immigration issue was one of the major issues that was focused on during the election, and many people actually cast their vote based on that single issue. The border crisis is actively being challenged in multiple states. Multiple states have passed laws like the Texas SB4 law, and then Iowa also has a clone law. And recently, 16 states joined together to actually sue the Biden administration and the Department of Homeland Security over this unconstitutional rule that the Biden administration put in place. And that rule by the Biden administration aimed to grant millions of people the ability to parole in place and then subsequently grant citizenship and essentially become legal citizens through a backdoor policy. The Biden administration, through the Department of Homeland Security, created a new program that effectively provided a new pathway to a green card and eventually citizenship for millions of individuals who came into the country illegally. Again, this was all done through unilateral action. This was done by the Biden administration through the Department of Homeland Security, and Congress did not authorize this program, but the agency engaged in overreach and did it on their own. As a result of this agency overreach, 16 states joined together and filed a lawsuit against the Biden administration, and it was filed in the Eastern District of Texas, and they wanted to strike down this new agency rule. The states that joined together in this lawsuit include Texas, which was the lead plaintiff, Idaho, Alabama, Arkansas, Florida, Georgia, Iowa, Kansas, Louisiana, Missouri, North Dakota, Ohio, South Carolina, South Dakota, Tennessee, and Wyoming. This lawsuit aimed to find that the Department of Homeland Security and that Biden administration immigration policy, that it was in fact unconstitutional and therefore must be struck down. Well, we just received a huge decision from the court here agreeing with the states and therefore striking down this Biden administration rule as unconstitutional and invalid. In this case, the states argued that this is a challenge to the unlawful agency action taken by the Department of Homeland Security, the DHS, to create a program that will grant hundreds of thousands of illegal aliens parole in place status, the PIP status. Long-standing federal law prohibits individuals who entered the United States unlawfully from obtaining most immigration benefits. This includes obtaining lawful permanent resident status without first leaving the United States and waiting outside the United States for the required time, based on an approved family-based or employment-based visa petition. These provisions of law established by Congress serve as powerful disincentives for individuals to cross the border unlawfully. Indeed, were they not present, there would be no practical reason for any alien to abide by the law, wait his or her turn, and only come to the United States when the law provides. But the Biden-Harris administration, dissatisfied with the system Congress created and for blatant political purposes, has yet again attempted to create its own immigration system in two new ways. Claiming that it has unfettered discretion, implementation of the Keeping Families Together DHS has announced the creation of a program that effectively provides a new pathway to a green card and eventual citizenship as well, announcing that it would allow more than 1.3 million individuals who are unlawfully present in the United States, more than 200,000 of whom live in Texas, to circumvent the process established by Congress to apply for permanent residency. Indeed, DHS aims to accomplish the end run around the law by unlawfully exercising the textual limited authority set forth in 8 U.S.C. section 1182, subsection D5, which states that the DHS secretary may parole into the United States temporarily under such conditions as he may prescribe only on a case-by-case basis for urgent humanitarian reasons or significant public benefit any alien applying for admission into the United States. Specifically, DHS has announced a new PIP program that would allow aliens who have been unlawfully present in the United States for 10 or more years to receive a grant of parole without leaving the United States and attempting to come back and apply for admission at a point of entry, if the individual is a spouse or stepchild of a U.S. citizen. However, one of the main challenges to what the Biden administration did through the DHS is that the parole power in the statute only applies and only allows parole of individuals on a case-by-case basis and only applies to individuals attempting to come into the U.S. The statutory language does not allow paroling mass amounts of people, mass amounts of individuals, and it also does not allow or should not apply to individuals who already are within the U.S. The Biden administration wanted to twist the statutory language, which is brought forth in this lawsuit. They wanted to change the statutory language, expand it, and engage in overreach to say that it applies to tons of people. It can be used at a broad sweeping basis. It can apply to a ton of people, not a case-by-case basis. And it can also apply to people who are already in the U.S., not people who are trying to come into the U.S. The states argued in this lawsuit that the new program was actively incentivizing more people to illegally enter in the U.S., and they were entering into various states, and that was causing millions of dollars in potential harm to these states. Now, this case was filed in a federal district court in the Eastern District of Texas, and it was signed to Judge J. Campbell Barker. Originally in the case, Judge Barker placed the immigration initiative on hold with a preliminary injunction, so he put a temporary halt on the enforcement of this program. Now, through this program, if an individual was already married to a citizen before June 17th, the day before the program was announced, they could pay $580 in an application fee and fill out an application explaining why they deserved the humanitarian parole in the United States, and therefore they did not need to return back to the nation of their origin. Now, if approved, the applicant would be allowed to stay in the U.S. and would have about 3 years to seek a permanent residency and obtain the work authorization requirements and try to obtain a green card and then ultimately citizenship as well. Now, it's unclear if anyone actually received approval under this program because of that temporary preliminary injunction that was issued in this lawsuit. There were individuals who applied, but we do not know if they actually obtained any approved status by the Biden administration before the injunction or even after the injunction was put in place. Now, one of the things the judge considered when granting the preliminary injunction was that there would likely be no harm to the individuals here who were seeking to use this program because they had alternatives. There was already a law in place, a process in place, and that typical process included only a 1 year long wait outside the United States. You could go to your own nation of origin to seek citizenship. You could go and file through their program. And so there was already a system in place. And so the judge here said, you don't need this new program. No injury will come to you by us blocking this new program because there's already a legal process in place. Well, this has all now come to a head, and a district court did issue a final decision finding that this Biden administration and DHS program is in fact invalid and therefore was struck down. In the decision, the judge stated that the court declares that defendants lack statutory authority under 8 U.S.C. section 1182, subsection D5A, itself as opposed to under other provisions modifying or supplementing that authority, to grant parole in place to aliens as the term is used in the final agency published in the Federal Register, or to deem parole in place as used there in the parole into the United States for the purposes of that section, 18 U.S.C. section 1255A. The agency action is hereby set aside and vacated pursuant to the statutory language. So there was a huge win that was just issued by a federal district court. This decision essentially strikes down the Biden administration and the DHS program that they tried to put in place to essentially legalize millions of people through a new program that was outside of the authority of the DHS. They engaged in agency overreach. They tried to create laws on their own, and here a judge says, no, you engaged in overreach. You do not have that authority to create this law, therefore we're striking it down. Now, in all reality, this program was probably going to be on life support anyways, especially with the recent win of President Trump during the election. I have no doubt that the Trump administration would have rescinded the program and he probably likely still will, because even if this is appealed, it's going to kind of still be on the books, and so I would suspect that he's going to rescind it. However, the good thing with this decision is that the Biden administration will not have the ability, they will not be able to utilize this program before the January inauguration of Trump. This program could have been wielded by the Biden administration if it was upheld to essentially legalize millions of people in various states, before the Trump transition. So this would have been something very concerning, especially when you have information about so many people being flooded into swing states. There was a lot of concern with that, but this program has been blocked by this decision. We will see how this plays out. We will see how the Biden administration decides to respond to this decision, especially now that they're kind of in the lame dunk period of the election. So we'll see how this plays out. If anything else develops, I will let you guys know. So if you guys found this video informative, make sure you like, comment, subscribe, and share this around. All those things help to fuel the algorithm. But as always, thank you all for watching. Don't forget to like and subscribe. And never forget, this station was built by Armed Scholars, and the station will be maintained by Armed Scholars.